Ladies and gentlemen, may I have your attention, please? Good morning. First, thank you very much to the Portuguese Competition Authority and its president, Di Nuno, in particular, for inviting me again here in Lisbon. Last time it was a real pleasure, I must say. I enjoyed the hospitality, the facilities, the level of discussions. So thank you for inviting me here again. But of course, it's also a challenge because last time it was the 20th anniversary of the authority, and it was relatively easy to make a speech. ADC exists 20 years, so you go to the ECN and you make a speech about the ECN and everybody is happy. But now, today, what can I say? It's not so obvious, especially because I'm squeezed in a very futuristic program. This morning we heard the mapping of the future of EU merger control, and after me, again a futuristic event, charting the next legal frontiers in antitrust enforcement. So I'm supposed to look ahead, somewhere into the future. That's something very uncomfortable for a judge to do. We are backward-looking people. We deal with conflicts that existed in the past, and we're often a bit conservative. That's called legal certainty in legal terms. So thinking about the future is not so easy. Even so, I will make an endeavor, because of course we know that when we render judgments, they have an effect in the future. We also have a look, of course, at trends when cases come in. Where are they about and how does it evolve? How do we plan also our activities in judicial terms? So I will make first an inventory of the trends which I spot before my jurisdiction and before the Court of Justice, and will try to infer from that some lessons for the future. And I will do so in 4 parts. First, I will make a quantitative analysis. What are the cases in quantitative terms brought before the General Court and the Court of Justice? So that will be the boring bit, just figures. But I thought since there are economists in the room, I might as well please them, because that's the only part of my speech where I'll be speaking about figures. The rest will be completely legal. Then I will make a qualitative analysis and have a look at the nature of these cases. Where did they deal with? What is it? And can we infer trends from them? And that will be the third part, the analytical part of the 2 previous bits. And then the more woolly bit, well, I will look into a crystal ball and try to predict some future developments. And I look forward to a discussion on that particular topic. So first, the quantitative bit. How many cases were brought before the 2 courts? But before dealing with this question, which looks very simple, there is a complex preliminary question. What is competition law? You might be puzzled by that question in a conference dealing with competition law. We would all agree that Articles 101 and 102 are definitively competition cases. Merger control, is that still competition law? Yes, of course, it still finds a legal basis in the chapter dealing with competition law in the treaty, so from a legal point of view, yes. But when it comes, for example, to state aid, that's something completely strange for Americans, for example. That's obviously something typically European. What about the DMA? It's Article 114 of the treaty. Is it competition law? What is it exactly? And how does it interact with competition law? And then we get another tool like the Foreign Subsidies Regulation, which has state aid components, public procurement components, and merger control components. So that makes it very difficult to make a quantitative analysis. So I will stick to the traditional bits 101, 102, and merger control, and also the DMA. Now, what strikes me is that competition law basically disappears from our court in quantitative terms. Let me give you two periods. One period is the period 2016-2020, where I mention average figures, and that period I compare to the period 2021-2025, also with annual average figures. First, cartel cases, 101. In the first period, we had around 14 cases per year on average. That has gone down to 7. Abuse of dominance cases, which are discussed at length at conferences, 5 in the previous period, only 1.5 in the subsequent one. By contrast, merger control is relatively stable, but you see a decline really in competition work. But in a certain sense, DMA, DSA has compensated a bit of the relative loss in incoming 101 work. For example, we have 7 cases per year coming in on average since 2023. So in total, we're now around 21. So that's the General Court, and it's interesting to compare that with what happens before the Court of Justice. There we see, of the whole period, a stable inflow from 2016 to 2025, with around 26 cases coming in per year, which is more than the incoming cases before the General Court. And when you have a look at the incoming work at the Court of Justice, it's 50-50 appeals brought in the cases against judgments of the General Court and preliminary reference proceedings. First, a point on these preliminary reference proceedings, so 20, I would say 13 per year on average, on a total which doesn't stop to increase. The court's workload is increasing constantly. I think this year they have already, in October, the same level of incoming cases as they had in the whole previous year. And this is going to increase over the years. It's also the complexity of the cases, which is interesting when you have a look at the cases before the court. And you see that the court is now struggling as well with the duration. The more cases come in, the more complex it becomes to deal with them in a short period of time. It used to be 16 months, now it's up to 17 months. Bearing in mind, of course, that an answer to a preliminary reference question is an incident in a national procedure. So that tops up on the duration before the National Court. That as regards the preliminary reference questions brought before the court. And then the second problem we note is the appeal cases brought against our judgments. First, there is a relatively high appeal rate. The appeal rate in general is around 25-30% of the final decisions taken by the General Court, and they go to the Court of Justice. But in competition cases, it can go up to very high percentages. So if you take, say, the period 2016-2024, it's 50% of the cases go on appeal. And they're complex cases. They swamp the court in many respects. And you see that the duration, the length of the proceedings before the Court of Justice in appeal cases goes up. For example, if you take the pay for delay cases, which took around 2-3 years before the General Court, 4 years appeal before the Court of Justice, the case goes back to the General Court because it was partially annulled, and there we go again. Very long proceedings. So those are the preliminary quantitative findings. Less work at the General Court, stable work at the Court of Justice, but in the context of increasing workload and high appeal rates. That was part one. Now about the nature of the cases. At the General Court, as I said, merger control work is relatively stable. It's a constant flow, around 7 cases per year. But what strikes me, it's the role of the nature of the applicants. Of course, you have those whose merger has been prohibited, who are dissatisfied, so they bring an appeal, for example, the booking case. That's an example. But most cases deal with disgruntled complainants. People say, oh, this merger should have been prohibited, or the commitments attached to the approval decision are not good enough, and it should be more stringent. For example, cases like Deutsche Telekom and the Stadtwerke cases in the German energy business. And of course, then we have competence questions, and one of those competence questions was discussed this morning, and it's in the context of the Illumina Grail story. We had, of course, those judgments from the court, but recently the General Court rendered a judgment in the Luxembourg beer case, where it accepted, or validated the Luxembourgish referral decision, but Luxembourg doesn't have merger control, so we are in a typical scenario as envisaged initially by the legislator. We will see what it yields in the NVIDIA case. That as regards the merger control cases. 101 and 102, not much I would say. We have, legacy cases of the air cargo type, Intel and things like it, still ongoing. I don't know how long that will last. I'm looking now at Fernando and myself. We probably have been retired before that all finishes. But there we have a problem, these legacy cases. And we see that now the pay for delay questions might lead to a similar problem, where you have protected proceedings, whilst having in national courts, national proceedings, relying on the decision which the Commission took, waiting for the outcome of the proceedings in Luxembourg. That as regards the classical 101 cases. On 102, what strikes me recently is that the interaction between 102 and the DMA cases. For example, we see the Apple case on steering in the App Store. Is that a DMA case? But it was brought under Article 102. Same thing with the Matter case. So that as regards a few comments on 101, 102. But more importantly, and that is perhaps a matter of concern for the enforcers here, is that fact-finding decisions, whether they are requests for information or inspection decisions, are systematically challenged before our court. I just mentioned the Matter case, Michelin, Red Bull. We have cases involving Vivendi, Lagardère, even under the new foreign subsidies regulation. These decisions are challenged. So, almost no cases coming in, and when the Commission looks for cases, the inspection tools are systematically challenged. Then before the Court of Justice, very interesting referrals, both under 101 and 102. For example, Google Android Italia is a typical reference case. The Super League cases of December 2023, also very interesting cases coming from the national courts. But when you have a look at the national courts, you have basically two categories. You have referrals which deal with review cases before national review courts, which refer questions to Luxembourg as regards the interpretation of the concepts which they have to apply. And you have the civil courts and standalone litigation involving competition law issues. And these, the follow-on cases seem to be in the majority. I counted in the period 2021-2024, 9 follow-on cases on, the cases coming in before the Court of Justice. That means that that work, which is at the Court of Justice, is also a derivative of the work of the European Commission. So that's what I wanted to say on the qualitative analysis after having done a quantitative analysis. Now, what trends can we infer from this? First, of course, the General Court still has competition work, and the cases we tend to get are the big ones. We also get the DMA cases and DSA cases. By the way, they're interesting cases because they break new legal ground. They're extremely legal. Economic reasoning, I'm now looking at the professor in the room, is systematically discarded by the legislator. So, but that's still something we do. Of course, what the General Court does reflects the activity of the European Commission. And there I have a cause for concern. We see less cases coming in. And why is that so? Because there's less leniency, and fact-finding becomes more and more problematic, especially when it is systematically challenged. For example, on the amount of leniency applications, I recorded 60 applications in 2011 and only 6 in 2022. And according to the OECD, Antonio, it reflects, say, a worldwide trend, probably also triggered by the actions for damages, which are then reflected again in the preliminary reference questions before the Court of Justice. So there we have, I think, as a group, a problem, because if the leniency applications go down and the fact-finding cases are systematically being challenged, how does our enforcement system work? Do we have a problem? At least from the perspective of my jurisdiction, the answer is it might well be that we have a problem. Now, if I look from the perspective of the Court of Justice, you could say, well, everything goes well. Tout va bien, Madame la Marquise. Everything is under control. We get still very interesting cases, but the consequence you can infer from the qualitative analysis is that the center of gravity has definitely shifted from Brussels to the national authorities, including the Portuguese one. For example, the leading cases, for example, Super League is a Madrid case. The Google Android case is an Italian case. And together with that, say with this shifting center of gravity, we have also in Luxembourg a collective problem with the duration of proceedings in the high-profile cases. Intel, I already mentioned, pay for delay will be another one. Draghi has mentioned that, for example, in the report, that that is a problem in its recommendations in Part B of his report. What can we do about it? We are thinking at the General Court what to do about it, but it's a collective problem we have to address. So appeal cases are problematic because of the length. 267, the center of gravity, is definitively at the level of the Court of Justice. And as I mentioned, the Court of Justice has a problem. It has a quantitative problem with incoming work, which becomes increasingly complex in constitutional and societal terms. If you have to deal with rule of law cases, complex societal questions, for example, on the question about wearing a veil in the classroom or on the employer's side, those are delicate questions which the court will deal with in the chamber of 15 judges, mobilizing a significant part of its resources. So the question on the long term, and that's where I will now look into the crystal ball, is the court, or will the court on the long term still be able to deliver in due course the quality judgments it delivers today? I think it's a question we have to think of today. Now, what can we do about it? What could we do? And that's where the woolly bit starts. And it will not be a surprise. An option could be to say, okay, part of the work which is now pending before the Court of Justice could be transferred to the General Court, as, for example, the Court already did last year when it transferred competence, especially in tax matters, from the Court of Justice to the General Court. And the idea is that these cases were too technical, they are specialized, they clog up the court and prevent it from doing its constitutional work. I think it's important that in competition law, consistency can be guaranteed, must be guaranteed on the long term. If you have a system where the center of gravity has shifted to the member states and they all apply the same area of the law, coordination is of essence. Of course, you have the Commission steering the system under Article 11 of Regulation 1, but at the level of the judiciary, if there is a distracted court, why not concentrate the activities at the level of the General Court? Now, of course, it's a bit early days to plead in favor of a transfer of competence in the field of competition law. The transfer of competence took place last year in October. We just rendered one judgment and one opinion, so we don't have much to boast about for the moment. But if you look in the future, I'm sure that this will work because it must work. There is no other way for the judicial architecture of the Union, that it is a system that should work. And the question then is, if it works on the long term, in the context of the revision of the competition rules, is there a case to be made to transfer competition law cases to the General Court? I think there is, of course, the element of expertise, because the interesting thing about the transfer of competence which has taken place is that the legislator has insisted that the transferred matters are dealt with by specialized chambers. I suppose a similar case could be made for competition cases. So you would concentrate the expertise, which also leads to a more efficient and faster decision-making. But of course, that's a choice to be made by the legislator in the future. The second point is we have the capacity. We have 54 judges. There's still room for additional work. And more fundamentally, there's also a case to be made on the consistency. Because when Commission decisions are challenged, they're challenged before us. The General Court controls the legality in the first place. And then when there's follow-on litigation concerning the same decision, the questions go to the Court of Justice. Would it not be wiser to combine the legality and the interpretation in the hands of the same jurisdiction? So there are cases to be made for this transfer. But it is not obvious. There is always a problem somewhere. And the problem is, of course, the appeal. You can't have, say, ensuring the consistency and uniformity of the case law with the General Court in preliminary reference cases, and at the same time have an appeal system before the Court of Justice, because there is a similarity between the appeal system and the preliminary reference system. There should be one final say by one court. And for example, in the Super League cases, you had preliminary reference cases originating from Spain, but at the same time you had an appeal case involving the International Skate Union, decided on the same date, say, raising similar type of issues. So it's important that the appeal system and the preliminary reference system are being coordinated. Now, how can you do that? There are examples in other areas of the law. For example, if you take trademark cases, the General Court basically has the final say. Only when there are issues of the consistency and the uniformity of the case law, the court will take a matter up, because the appeals are being, say, I will use the word because that's the word we use internally, but I would like to invite the journalists not to mention it in what they say. The court filters the questions. Only when there is a case which involves the consistency, uniformity of the law, will it accept an appeal. If not, it will deal with the appeal by a simple court order. And that is because in trademark cases, there is an appeal board in Alicante which reviews the decisions at the administrative level. And these appeal boards are quasi-judicial in nature. And they guarantee that in the level, say in trademark law, you have judicial degree at two levels. First by the appeal board, then by the General Court, and when it comes to constitutional questions, before the Court of Justice. You have a similar system in REACH. You have, for example, also the railway body. You have it in banking systems. I think there's a case to be made, but that's, I think, a question for debate, for future conferences, to build in a device like that in the enforcement before the European Commission. Either ex ante, for example, following the banking model, where the single resolution board, for example, in the banking sector, takes a decision, but which becomes only a final decision if approved by the Commission. But there has already been a board having a look at the problem, and we could say we could envisage to build in a system like that in Regulation 1. Or it could be ex post with an ex post expert board, also within the context of the Commission. But of course this raises all sorts of complex questions under the Moroni case law, to which extent the Commission can delegate essential tasks to to these type of bodies. But if we think in constructive terms, and I think on the long term we need to do that, because I would also submit that it would probably render the decision-making before the European Commission more acceptable for companies when they are heard by an administrative judicial body internally than the system we have today. But of course, this is all crystal ball gazing because I had a futuristic and prospective slot in this program, and I thank you very much for your attention, and I look forward to future discussions. Thank you very much.